Good morning, members of the jury. I want to begin by thanking you for your time. I know we all learned a lot more about plumbing and patents than we ever thought we would. But in all seriousness, this is a very important matter to both sides. And I want to thank you for taking the time and being attentive and the patience you've shown. I know it's difficult to take time away from work and family to be here, but it is important for both sides that you've done that. And I want to thank you on behalf of myself and the trial team and WCM for doing that. If we can have the slides. When we began this case, we presented evidence to you of Mr. Ball and his inventions. And one of the issues that we've presented is, did the innovator come before the classic? And we presented a lot of evidence from Mr. Ball, who's the named inventor of the 3 patents that you've heard a lot about, showing the problems that plumbing systems had in the 1990s and his efforts to make a better overflow assembly. And he talked about the unanswered problems with 2 holes and the 1 holes that were installed in the field. He performed extensive research and development on these issues to try to come up with something that was better. As he explained, in doing this process, every little detail mattered. He looked for ways that he could find to fix the leaks that were occurring because there wasn't a proper seal, and he demonstrated that for you so that there'd be a better system in assembly that would not lead to leaks that caused mold and mildew. He had a database of 700 different bathtubs that are in use in the United States. Why was that important? He wanted to find a way that he could have one fitting, one type that would work and would alleviate these problems. Testified that he began, and we'll get into a little more detail later, but he testified that he first began this process in 1999, and you'll see detailed drawings that he had in December of 1999 that were computer-aided. He considered many prototypes in the 1999-2000 time period. He repeatedly experimented with thread size and pitch because all of that had to fit just right. Every measurement mattered. Every nuance mattered to get this right. And he explained to you that the innovator's thread you see on the product, that's not standard in the industry. Something he came up with was the only way that he saw to solve these problems. You're going to see some of his drawings, and we'll go through a little bit more of them later. Ultimately, in June of 2000, he filed a patent application, and several patents have issued since that date. Now, what do we know about AB&A? What do we know about whether the classic came later? Well, we know that AB&A had no engineering, they had no research and development, and they had no manufacturing. That was all done by another company in another country. We know that Mr. Todd Rico, who was the national sales manager for AB&A, saw an innovator and put it into the hands of one of the Oropala brothers. And a few months later, they had a product. They had the classic. You didn't see any drawings. In fact, Mr. Oropala testified he couldn't remember any drawings. So Mr. Rose, on behalf of IPS, told you in an opening statement that there were drawings. In 2002, well, there are no such drawings in the record. And Mr. Oropala couldn't remember any such drawings. That's because what they did is they didn't invent their own product. Someone who had invented their own product would remember. Mr. Oropala couldn't remember anything about this. They'd remember like Mr. Ball did. Mr. Ball testified before you and explained his inventive process. So there's no dispute that the classic was just a copy of the innovator. What did we also learn during the trial? We also learned from Mr. Humber that he followed Watco, WCM's division that Mr. Ball worked at while he created the inventions that led to these patents. We learned from Mr. Humber that he got brochures and the like from Watco. And we learned that he followed Watco long before he followed ABNA. So he had to have known that the innovator came before the classic. Now fast forward to 2010. That's when Mr. Casella, on behalf of IPS, becomes interested in acquiring ABNA. Mr. Casella is told some important things, and he learned some important things, and he explained that on the witness stand. He told each of you that he knew the ABNA told him that WCM had repeatedly accused them of copying. What did he do in response? You heard his own counsel ask him a question. Did you ask the Orapalas whether they'd copied WCM? And the answer was that he didn't even ask. Didn't even ask. And we also learned that there was litigation between WCM and ABNA before that acquisition. Mr. Casella knew about that. ABNA had copied WCM's quick trim kit, for which it has a patent. It's called the 083 patent, and that's in evidence before you. And they agreed in that settlement agreement that Mr. Casella signed not to put out that product anymore. So that's all information that IPS had before they acquired ABNA. So they knew what they were buying, and they went ahead and purchased it anyway. After that, after the acquisition, we know that they came out, IPS did, now we're talking about, they came out with a trim kit, a press-in trim kit that also copied and infringed the 083 patent, the quick trim of WCM. We also learned, we'll go into this in a little more detail, later that Mr. Kirk, one of IPS's employees, wanted to knock off one of the innovator Flex products. That's IPS. We learned that Mr. Jaffa, their exclusive sales representative in the East Coast, wanted IPS to copy the Universal New Fit, which Watco has won an award for. And what was the response to these issues? It wasn't, oh no, we don't do that. Oh no, we don't knock off products. That's not us at IPS. No, the response back was an email forwarding this to Mr. Kirk, another IPS, and forwards Mr. Jaffa's email with the brochure saying, this looks like a good idea, can we do it? And Mr. Kirk asked Mr. Humber, who's the director of engineering, to set up a product development meeting. And that's all happened very recently, all after IPS acquired ABNA. So what we've presented is that the ABNA part of IPS, which Mr. Humber said hasn't developed a new product since IPS acquired it, has a pervasive culture of wanting to take ideas of others and copy them or knock them off. So what we have in the record is we have Mr. Ball's drawings of his threaded pattern, and you heard him testify before you how long it took him to come up with that. And he explained that he had to experiment, that it all had to work out exactly the right way. And which exhibit number is this? Okay. So 53 is on the left and 137 is on the right. 53 is the WCM drawing. And if we can call out the thread pattern from that, we're talking about the thread pattern for this overflow elbow that inserts into the tub. And you're going to see that there's a 2 3/8 right there. And remember, Mr. Pascal admitted that this was not standard in the industry. This was set by the manufacturer. And Mr. Ball testified how long that took him and how much experimentation it took, because you had to get all of this just right for the nut to work. So this would compress the washer against the tub the right way so that it wouldn't leak. And we also have on the right the IPS drawings that they have in 2011. These are their drawings in 2011 from Taiwan. And the thread size and the thread patterning is identical. And that's because it's a copy. And there's no way around that. So I want to close with one of the court's instructions that I believe you'll be receiving, if I might have the Elmo. I believe you'll receive an instruction on what's called willful blindness. And that occurs when a defendant takes deliberate actions to avoid confirming a high probability of wrongdoing. In order to establish that, we have to establish that IPS subjectively believed that its actions would result in infringement, and IPS took deliberate actions to avoid learning of the infringement. And when you look at the copying, when you look at what they knew about copying, when you look at what they knew or had to know about the key products that AB&A had, and they knew about the innovator in the marketplace, and there's no way anyone can look at these and not think that they're nearly identical. And they even got an indemnity provision. But they failed to ask the Orpalas whether they copied. That's that deliberate indifference we're talking about. So in conclusion, I want to thank you again for your time and patience. At the end of the day, you should find that WCM's patents are infringed by the IPS classic products, that the patents are valid, that a reasonable royalty is at the high end of the range between $1.50 and $1.90, and you should find that the infringement was willful. Thank you very much.